Good evening, everyone. Welcome to Cedar Management Group's webinar on the Corporate Transparency Act. Hope everyone is having a wonderful evening. I want to thank you all for joining us. Before we go ahead and get started, I just want to cover a few things before we get into the heart of the matter. First thing, I want to thank you all for attending. It's 6 o'clock on a Tuesday or Wednesday, whatever day of the week it is. And we are super happy that you've taken the time to spend time with us because the Corporate Transparency Act is very, very important. And if you are a board member or a director of a community management association or a community association, you're going to be impacted by this. I want to be clear, this is not something that Cedar Management Group passed. It's not something that we endorsed. It's not something that we really had anything to do with. If this is a federal law that was passed that will impact, again, most directors and most board members of community associations. So if that applies to you, we're very happy that you're here, and we are here to provide education for you this evening. There's going to be nothing you need to do immediately. And we will go over at the end of this presentation how this will impact you directly and what you're going to need to do, what the next steps are. But tonight, what we have for you is a basic education about the Corporate Transparency Act. It's known as the CTA. That's what you'll hear us refer to it as. And tonight we have Nick Meinert. He's from Kaman and Cusimano Law Firm in Cleveland, Ohio, and he's going to be providing us the education about the Corporate Transparency Act. Kaman and Cusimano is a law firm that is specifically deals with community associations. So this is their business. This is what they know. And Nick is one of the experts. So Nick, really appreciate having you on tonight. And we're going to go ahead and get started with the webinar.
All right. Thank you, Lisa. Not much more introduction I need after that. Thank you so much. It's a pleasure being here with you all today. My law firm exclusively represents condominiums and HOAs in Ohio, Wisconsin, Kentucky, and Tennessee. And so I'm prepared tonight to give you all a presentation. After the presentation, I'd be happy to hang around and answer any questions that you do have. But without further ado, let's get started. So the Corporate Transparency Act, it was enacted by Congress in 2021, actually. It's part of this National Defense Authorization Act. And so it's not being implemented until now. Corporations aren't required to file their registrations until the end of this year. But it has been a law for a while. It's only just now being talked about because corporations are being required to abide by it and follow it. So the whole idea behind this law is it's intended to help prevent and combat money laundering and funding of terrorist organizations. So at one point in time, federal government did a study. They realized, hey, there's all these small corporations that are being set up all across the country. They're really just shell corporations. And what's happening is different money launderers are just funneling money through these multiple corporations from one to the next, to the next, to the next, using it to hide their money laundering, using it to finance terrorist organizations. And so the whole idea behind this is trying to prevent that by requiring people involved in those corporations to register with the federal government. Now, the federal government bureau that you're going to be required to register with is called FinCEN. So it's part of the United States Department of the Treasury, just like the IRS is a bureau of the United States Department of Treasury. FinCEN is as well. And they collect and analyze information about financial transaction in order to try and combat these types of things, combat money laundering and terrorist financing. So all of this originated out of that one goal to try and stop that. And somehow community associations got looped into that. And we're going to talk a little bit more about how that came to be. But who must comply with the Corporate Transparency Act? Who does this affect? It affects all quote unquote reporting companies in the United States that have a bank account. And so a reporting company, it's got a very general definition. It's any company that's registered with the Secretary of State in whatever state that they're filing in, and it doesn't fit the exceptions. So any corporation that's incorporated with the Secretary of State of one of the 50 states, those corporations are obligated to file unless they fit one of the exceptions. So if you're a condo, an HOA, and you're incorporated, which most are, it's a very good thing to be incorporated. It protects the board members, protects the owners. You're going to be required to to comply with the Corporate Transparency Act, just like obviously management companies are all incorporated, and so it may affect them as well. Here are the exceptions that might apply to community associations or management companies. And believe me, my firm has spent hours and hours of unbillable hours pouring through the statute, trying to find ways out of it for our clients, and we simply cannot do it. This is the only potential one that could apply. You have to have more than 20 full-time employees. You have to have filed an income tax return with more than $5 million in gross receipts. So that right there, 20 full-time employees and 5 million in gross receipts, that's a tough barrier for a community association to meet, unless you're some massive bunch of high-rise condominiums that are all one association. You've got a bunch of employees and you bring in a ton of money every year. You have that physical operating presence in the United States. You have to satisfy all three of these requirements to be an exception. So a lot of communities are asking me, Nick, we're so small. Are you sure we have to comply? And that's exactly what this law is designed to do. It's designed to require small corporations to comply. So it's only the very rare, extremely large corporation that has more, or community association that has more than 20 full-time employees and over $5 million in gross receipts that are going to be excluded from needing to comply. So is the association a reporting company? Yes, almost certainly yes. Are management companies and business partners, those business partners that provide services to community associations? Likely yes for the company itself, depending on the scale of the company. Obviously, there are large enough management companies that satisfy all those requirements, and they don't need a file. But for the most part, we're talking about management companies and community associations that are going to need a file these reports with FinCEN according to the Corporate Transparency Act. Now, what type of report are we filing? We have to report the quote unquote beneficial owners. So let's talk a little bit more about what makes people a beneficial owner. Beneficial owners are anyone who directly or indirectly through any contract or relationship either exercises substantial control or owns more than 25% or owns 25% or more of the entity that is the reporting company. So many people focus on this 25%, owning 25% of the entity, and that's actually the easy part. And when it comes to community associations, it's going to be a very rare situation where you've got somebody owning more than 25% of the corporation itself. But the exercise of substantial control standard is really what is going to bring in the board members needing to register as beneficial owners. So let's talk a little bit more about that. Substantial control, it's codified. There's a whole list of standards and explanations in that federal statute that creates the Corporate Transparency Act that tells you exactly what substantial control means. So it certainly means the president, because they're the chief executive officer, and that's automatically included. If you're the chief executive officer or you're the president of the board, you're a beneficial owner. But what's more is it says that anyone who's authorized to elect or appoint that chief executive officer, they are also considered to have substantial control. And so I know that I would say 99.9% of the communities I work with, the owners elect a board of directors, and then the board of directors from amongst themselves appoint the officers. They appoint who the president is. And so if the board is appointing the chief executive officer, the president, all the board members are also have substantial control. But beyond that, beyond just being able to appoint the president, if you go through the list, you're talking about making important decisions for the corporation, substantially important decisions for the corporation. We're talking about people who are authorized to execute or to decide to enter into a contract on behalf of the corporation. Guys, that's the board members. The board members are the beneficial owners because they exercise substantial control. They make and direct almost all decisions on behalf of a community association. And so because of that, all board members are almost always going to be beneficial owners out, forgetting about some very rare and obscure documents that may exist out there. All board members are on the hook. All officers are on the hook. Our committee members, what about committee members? We get this question a lot. What about the Architectural Control Committee, and things like that? Committees are typically created in order to make recommendations to the board. Making a recommendation to the board is not making a decision. There are certain committees that will eventually, make decisions. Some architectural control committees are authorized to approve and deny, the applications for architectural modifications. But that's such a limited scope of what the corporation's responsibilities are and what the responsibilities of what the corporation actually does. And so we're saying committee members, you're not required to register. You're not beneficial owners, even if you are one of those types of committee members who do actually, in fact, get to make decisions. Community association managers do not have substantial controls with respect to their association. Again, they may be given certain types of authorities and leeway in a management contract, able to spend certain amounts of money, enter into contracts up to a certain amount, but that's all contractual. The board can also terminate that management agreement, even if it's a matter of paying a penalty or damages or something like that. And so again, we're really just talking about the board members and the president who are obligated to register as beneficial owners. So this is the list of the different items that each beneficial owner is going to be required to provide FinCEN. You got to provide your full legal name, date of birth, your current resident or business address, and some type of identifying number, whether that be a passport number or a driver's license number. There's also this FinCEN identification number. We get a lot of questions about that as well. You don't need a FinCEN identification number in order to register as a beneficial owner. The FinCEN identification number exists for situations where you have one person who has beneficial ownership of tons and tons and tons of corporations, and they're going to have to file hundreds potentially of these reports. So instead of inserting all this information on each of those reports, they just have to provide, they register one time for a FinCEN number. They then give that FinCEN number on the application with each corporation. And so, for the most part, we're going to forget about that FinCEN identification number. We're talking about your name, your date of birth, your address, one of the passport or driver's license numbers, and then you upload a copy of that document that you found that identification number on. So you're either going to give them your driver's license number and upload a copy of that, or your passport number and upload a copy of that. Not as intrusive as we initially thought, as we initially was talked about. I know there's a lot of talk at the beginning about providing social security numbers and all kinds of other information. And that's not the case. It's fairly limited. These documents, certainly a passport's provided to you by the federal government already. They already know all that. A driver's license is, albeit given to you by your state government, but the federal government and the IRS, which is, like I said earlier, already a department of the Treasury, they, already have your social security number, which is way more sensitive. So not as intrusive as initially thought, although, understandable that some people will look at this and say, this is one more piece of information I have to put out there, and I'm simply not going to do it. But again, not as intrusive. There's several ways to submit. If you go to the FinCEN website, if you just run a Google search of Corporate Transparency Act beneficial owner registration, it's going to take you right to the page. The first thing that pops up is going to take you right to this page where you can either insert the information on the web or download a PDF, which you subsequently upload to FinCEN's server. The submitter is going to have to provide their name and email address as well. A lot of third parties are also setting up portals. There's law firms, accountants, management companies who are setting up their own portals, these third-party secured portals that's going to take in all that information and file the report for you. So if we don't feel confident enough to submit it ourselves, there are other options out there for community associations. But these are the things to think about when you're submitting. There's only one submission per association. So it's not a matter of each beneficial owner going in, filling out an application and sending it to FinCEN themselves. All of the information from each of your board members is all going to have to be on one application. And for that reason, a lot of board members will feel more comfortable using one of those portals because they're giving it to a secured third party. You're not saying, I know plenty of board members that don't get along and wouldn't want to give one of their board members their driver's license and have them have their driver's license number. And so there are these options of these third-party portals for that very reason. We're all having to put this on one document and include it all together. Two main sources of liability associated with submission is one, submitting correct and complete information, obviously. There are penalties for that, which we're going to discuss here shortly, but also holding and storing all that personal identifiable information. Personal identifiable information, if it leaks out, there's a tremendous amount of liability associated with that. And again, a lot of these third-party portal entities are already companies that have secure portals. They're already used to handling tons of sensitive information. They already have tons of personal identifiable information that they keep safe on their server. And so this is going to be just another one of those things. They already have the wherewithal and the capabilities, the equipment to do it and to protect your information. So when are we going to submit? Submissions are required by the end of this year. So by January 1st, 2025, all reporting companies need to have filed these beneficial ownership reports. So we're recommending, doing so during the third quarter, unless for some reason, even waiting until the fourth quarter is fine. If you are going to have your annual meeting in November, don't file your report in October because you're just going to need to update that information after the annual meeting. Same if you know that, well, hey, look, our board president, they're going to move in October. Well, let's not file that beneficial ownership report in August because we're just going to have to remove them from that once they move in October and they close on their new home. So keep that in mind when we're filing, because as you can see at the bottom here, reporting companies have to update the information annually and within 30 days of any change of beneficial ownership. So at least annually, we need to be filing this. And anytime that information changes, we need to update as well. So board member gets really upset during a board meeting and storms off and resigns. I'm sure nobody on this webinar has ever seen anything like that happen. Well, we need to know going in, like, what does it take to resign? Does it have to be in writing? Can they do so verbally in an open meeting? Because that is going to impact us now in different ways that it hasn't before. We're going to have to update that beneficial ownership information. So make sure we know how and when people can resign from the board. So I talked earlier about penalties. There are penalties for non-compliance, not more than $500 for each day that a violation continues, including failing to update information. So if we provide false information, we don't file at all, we don't file an update, these are all different ways that we can face these penalties. That $500 a day is capped at $10,000. Thank goodness. And you can also be imprisoned for up to 2 years. And there can be a combination of the fines and the imprisonment. When it comes to who is going to be responsible for that, it could be any number of people. If you do a deep dive into this FinCEN frequently asked questions, they've got a lot of information out there. One of the bones that I have to pick with them is that there's been no advertising campaign, though. How are all these small corporations across the country supposed to know that they're supposed to even file this report? Most people don't even know that. I was down in Washington last November lobbying with Congress people, meeting with the members of the Senate and the House, explain to them, like, look, beyond community associations, why do community associations have to do this? But beyond that, I know so many small business owners of landscape companies and things like that, that have no clue that this even exists. And so there has to be some type of advertising campaign, but there's not, and we can't expect a delay in this. We're all going to have to comply. Um, and so, it's something to keep in mind. We're talking about penalties for if there's a board member who's failing to provide the information and they're holding the whole corporation back, they can be liable. If there's a third party submitting it for you, or the board president submitting it, and they provide false information, they can be liable. The whole association, the corporation as a whole, can be liable if they're not filing that report. So there's multiple different avenues that they can pursue to really compel you and provide leverage into getting this information out of you. So let's talk about what if there is that board member who refuses to provide the information. I'm sure there are people on, on this webinar right now that have had board members say, well, I'm just not going to do it. I'm not going to give you that information. So let's try and get ahead of the game now. The board can pass a rule that requires that information is provided to the rest of the board by a certain time frame. If it's not, we can, fine them, levy enforcement assessments against a non-compliant director to try and get them to either resign or give us the information. And there are certain condominiums that are able to amend their governing documents in order to comply with the law. And so if you're one of those types of condominiums, or if you're an HOA that has a nice provision in your governing documents that allow you to do that, certainly encourage the board to go out and file an amendment that makes one of the standards to being a board member that you've provided this information to the rest of the board. So you can be elected at the annual meeting, but you're technically not a board member until you provide that information. The reason being, if you're elected and we create a deadline, 10 days, you got to provide it. Well, now we're kind of in this limbo. Do we have to file a report that you were on the board, but then off the board? But then how do we even provide the report that you were ever on the board to begin with if you won't give us your information? Difficult situations, and there's no guidance on how we would deal with something like that right now from the federal government. So if we are able to file that type of amendment that makes a board qualification that you've already provided this information, all the better. There is still a little uncertainty when it comes to the Corporate Transparency Act. There is a federal court in Alabama that ruled it unconstitutional. I know CAI and everybody was jumping for joy when that happened until we realized it only applies to the people who filed the lawsuit. Real helpful, Alabama. And so that doesn't help us. There's still a possibility that Congress will delay the implementation, but I think we all see how dysfunctional Congress can be, and how difficult it is for them to even pass a budget to keep the federal government going at times. And so it's really unlikely that we're going to get that, assistance from the federal government. So we need a plan. We need to get a plan together. We need to be ready to file our beneficial ownership information, and really just grab the bull by the horns and take this into our own hands. We can't expect that there will be some type of relief. I know CAI either has or is planning on filing a lawsuit to try and get this so that it does not apply to community associations. Even if that's the case, I don't see that going anywhere within the year before we're required to file once. So, again, we need to take matters into our own hands and make sure that we are ready to file, start collecting the information now. So I want to thank everybody for tuning in, and certainly, want to hang around and answer any questions that you have. I already see that we got 11 here at the bottom.
We do have some good questions in the Q&A, so if you'd like to go over some of those, we'd really appreciate it.
Sure, absolutely. So here's a question. What is the federal statute that enacted this? Well, it says, why is the federal statute? I kind of went over why at the beginning. It's an anti-terrorist, anti-money laundering, geared towards small corporations that were, being found to being set up as shells to just kind of funnel money through, back and forth between them to try and hide a paper trail so that they can hide taxable income and things like that, or dish off money to terrorist organizations. What is the federal statute number? If you Google Corporate Transparency Act, you're going to get that number will show up. I don't have it off the top of my head. Does this apply to a community that has a board in place but is still under developer slash declarant control? That's a very good question. So typically, When a community association has a board in place that's under developer control, the developer is the one appointing the board members, but the board members still make the decisions. And so those board members that exist that are making a decision, whoever's authorized to make those decisions are going to be the people that are beneficial owners and have to register. So probably the developer themselves, along with whatever people are included on that board. Wouldn't that mean that everyone in the community has to be registered since the whole board is elected by the community? So what you're mistaken there is that I said that the people who are authorized to appoint the president, not elect the board members. Remember, we got to keep those two ideas separate between board members and officers. We have board members who are elected by the members of the corporation in order to make decisions for the corporation. But then we have the board members typically will appoint who that president and what those officer titles are. And so, we're talking about the board members are authorized to make the decisions. Potentially the biggest decision, what I try and tell owners at every annual meeting is the biggest decision is electing these people who are going to eventually make the decision. But no, all the owners don't need to register, just the board who's really authorized to, enter those contracts, make those decisions, deny requests, file lawsuits, hire management, all that good stuff that really makes the community go. Would you mind explaining the exceptions again? At some point, it wasn't clear to me whether the items listed were meant to say small associations are exempt or if they're meant to be thresholds, exemptions for large associations. So they are exceptions for large corporations. So again, this is geared towards small corporations that really, they were finding don't exist really at all other than on paper, and filing a, tax, income tax that reports nothing, and is really just moving money in and out of it. So this is geared towards small corporations. So again, unless you have over 20 full-time employees, you bring in over $5 million a year, and you have a physical operating presence in the United States, you are not exempt. So to be exempt, you have to have over 20 full-time employees. To be exempt, you also must bring in over $5 million a year. So again, it's geared towards small corporations and small associations. How can they make one person responsible for a whole community? Our community HOA is a volunteer position. Almost all, all HOA, board positions are volunteer. And that is one of the issues and why we try and, lobby against it applying to community associations. But, one person isn't responsible for the community. The board is really responsible for operating the property, directing the corporation, operating the corporation, and things like that. So this isn't a matter of it being on one person. The board needs to have one person file it for them. And there are third party options out there, like we already discussed. What happens if nobody on the board wants to give out this personal information? If the board all declines, does the association have to disband? So it's not that simple. The association really can't disband. There are legal documents tying it all together deep in the property records, most likely. And, and each state has its own requirements of what it takes to disband. Some states don't have statutes regarding HOAs, and it will be whatever in your documents, but it's usually pretty rigorous in order to dissolve a corporation and also in order to make it so that the restrictions no longer apply to the property. And so that's not going to be the case. What's going to happen is if we're saying, okay, we're the board and we're just not doing it. Well, now if you're ever caught and the association is pursued, we're talking about the board members potentially being individually liable for this. We're consciously making a decision to violate federal law and subject the entire corporation to penalty. And so I don't care what state you're in, the fiduciary standards of being a board member of a corporation, a duty of care and loyalty to the corporation. And so if we're knowingly violating the law, we're not we're not going to be protected by that corporate veil. We could be personally liable for any damages that any of the owners have to pay, even if we're a board making that conscious decision. Will this material be shared after the call? Lisa, I believe you are sharing the whole slideshow will be available to everybody. So you'll be able to
Yes,
take these slides with you, review those exemptions, review the penalties and things like that. Can you provide the names of third-party companies that will help us do this? Do they tend to be expensive? Lisa, I think you know one, right?
I do. So Cedar Management Group is going to be providing this option for you. We are working with a third party provider right now who is in the process of creating an option for us to be able to collect this information, secure this information, and submit this information. So we don't have those details for you yet. And that's a good thing because we don't encourage you to file right now. We do want you to wait until late into the third quarter or early in the fourth quarter, depending on when your annual meeting is, before you file. So there's going to be a lot more information we're going to be sharing with our boards about how and when to file. And that is not the purpose of today's call. The purpose of today's call is really just to give you the basic information about this, to let you know that it's coming, to let you know that it applies to 99% of all community associations and boards, and get you prepared for the fact that you are going to have to comply with this law. So, or most likely going to have to comply with this law. There could be a Hail Mary at the end that postpones this or negates it, but at this point, unless something changes, we are going to have to comply, most community associations.
Yes. And so one question was, how are HOA seen as having beneficial ownership? The HOA itself doesn't have beneficial ownership, but the board members are beneficial owners of the corporation. So if your HOA is incorporated, you're registered with the Secretary of State, you do not meet the exceptions, then that is a reporting company. And so the beneficial owners of the reporting company have to file, and that would be the board members because they exercise the substantial control. Applying to FinCEN, will it be free? Filing the application itself is free. You don't need to pay to file the application itself. If you use a third party, you'll need to pay, pay to have them file it. Obviously, all of the companies that I've been seeing doing it are extremely reasonable. So usually, less than you would pay to have. Certainly less than you'd pay to have an attorney review a contract, certainly less than you would pay to have probably an attorney attend your annual meeting. So, I wouldn't worry about the cost associated with using a third party. There's a lot of competition out there for, in these portals as well. Especially if you're using Cedar Management, they're already your manager. They're going to be able to really stay on top of it and keep things updated for you in an efficient way. And finding those third parties that are going to do it efficiently for you helps keep the cost down almost always. All right, so we definitely have time for a few more here. Let me see if I can find some good ones we haven't answered already. What if your annual meeting's in December? Wait till after the annual meeting for sure. Filing one of these applications, certainly the board members who aren't up for election, if you have staggered board terms, and not all the board members are up for election, get their information now, have it ready. So you only need the update, but there's no sense in filing because then you're going to have to update it again anyways. So unless we're talking about, a New Year's Eve annual meeting, there's no sense in doing it now. And, gosh, I wouldn't want to be the one to attend that annual meeting. Let's
Yeah.
see here.
One comment that I
Yeah.
do want to make and make sure that people understand, when we're talking about changes, that includes your driver's license expiring and being reissued, your passport being expired and reissued. And remember that we're filing one time per association. So if there's any one change to any one board member's record, the entire thing has to go back in and it has to be submitted. Is it within 30 days or 60 days, Nick, that it has to be resubmitted?
30 days.
Within 30 days. Okay. So it is really, really important not to do this prematurely, certainly not to do it right now. we do want to wait until later on in the year to go ahead and collect this information. But like Nick said, if you know that you're going to be on the board and you're the board president, and you know that your secretary and your treasurer aren't going to change, but your member at large might, go ahead and collect everyone else's information, get it ready so that when it does become time to submit this information, you're prepared. It'll make it a lot easier for you and a lot easier for your third party provider as well, which
Definitely,
we are
definitely,
going to volunteer to do, but you don't necessarily have to use us.
definitely. Um, Gosh, so I saw one here. Can the HOA incur liability if a contractor or service provider is not registered? No. That would be on that corporation and those beneficial owners who would face liability for that. We don't have to ensure that all our service providers are properly registered. Gosh, that would be even way more overkill. So all good there. Our community is 48 townhomes, about 40% are rentals. We can't even get a quorum to change our covenants. We can't get volunteers to serve on the board. Obviously every corporation needs board members. The community association needs board members. I know this is gonna make it more difficult to do so, but you just have to do what you got to do in order to comply. The board members that you do have, will have to file these beneficial ownership registrations. And Lisa, if you see a good question in here, certainly, go ahead and just fire it out to me. I see your question. What about if the HOA is a 501c? 501cs are, to my knowledge, are charitable. They have charitable purposes. HOAs do not have charitable purposes. HOAs have to file tax returns. HOAs do not have a charitable purpose. Our purpose is to take care of the common elements, to enforce the restrictions, mainly, almost always. And so we're not going to meet any of those exclusions under the 501c exceptions.
One of the best questions I've heard, and a lot of people wonder about this, is every association, most associations that are responsible have an insurance policy that covers the association. And I've heard a lot of board members asking about whether or not that will cover the board if fines apply or something else happens. Would you like to address that?
So I review a lot of insurance policies. I also pursue a lot of insurance companies who deny coverage for our clients. I would say pretty much every single insurance policy I've ever read has an exclusion for intentionally violating the law. So no, the insurance is, your insurance company is going to deny coverage if you say, hey, we just got $10,000 of fines for not filing a beneficial ownership report. So no, insurance isn't going to really be a big help there for us, unfortunately.
And I will share one anecdotal story. This is our second webinar. We did one last week as well. And as soon as it was over, we had a board member reach out to us and said, "We're not going to do this. We're not complying. And I just want you to know that." And our response to that was, we can't force you to comply, but this is a federal law. This is not something that Cedar Management Group is asking you to do. We are simply here to provide education and to help facilitate your filing. If you choose not to comply and the federal government chooses to enact penalties against you, there's not going to be anything you're going to be able to do to prevent those penalties from applying to you. So we really encourage you to go ahead and make sure you're prepared to comply with this law. And I've seen some chatter in the comments and the questions. There are a lot of people trying to make this law go away. I myself have been to Washington and I've talked to Tom Tillis's staff in North Carolina. I've talked to a lot of the different congressmen in North Carolina staff. Most of our congressmen and senators realize that this should not apply to community associations. But I think most attorneys and most people who have done a lot of research on this law all agree that it's unlikely to occur before January, before the filing requirements take place. So we are preparing to have to comply with this law. And as I said earlier, if there is a Hail Mary that it ends up not being the case before January, then great. The worst that can happen is we were over prepared. But we do not anticipate that will happen. And if you have, I saw one other question. If you have an annual meeting scheduled in January, you're going to have to file once before 12/31 of 24, and then you'll have to file again in January if anything changes at your annual meeting. If you have your annual meeting and all your officers stay the same, there's nothing you need to do. But if anybody changes an address, a driver's license number, a passport number, you get a new officer, somebody relieves, any of that happens, you're going to need to refile.
Great point, Lisa. Great point. And so I see one good one here as a point of clarification. So all the board members have to provide the information, but only one board member has to file it for all the board members. Yes, or some third party, keeping in mind that, it's one application. That's why it comes down to that. It's only one application that we file. So somebody does have to push submit on that application. Everyone puts their information in one long document. And so that's why it seems like, yeah, one board member is going to have to be the person that says, this was me submitting the information. And I
When
see a
you
lot
use
of
a
questions about enforcement too, like, hey, are they really going to come after us? Who's enforcing this? FinCEN's enforcing this. I'm sure there's plenty of people in here who have never been audited too. And so that doesn't mean people don't get audited. Also, yeah, we have no record of how they're going to enforce this, who they're going to go after, how many people they're going to go after, how many corporations they're going to go after, and things like that. And so it may be unlikely. I don't know that. It may be likely. But also, just like Lisa said, all we're here to do is provide you the information and let you know that it is required and what could happen if you don't, is so that, hopefully we make, good decisions and actually do provide the information. Because there is no, there's no record on that. There's no history. We don't know.
I have heard some concerns about board members not wanting to share their personal information with other board members so that one board member can do the submission. And these third-party providers, including the option that CEDAR is going to have, are going to keep that information private from each other. So one board member will be able to submit their information, another board member submits their information separately. It goes into a secure portal, and then someone at that third party would hit submit, thus protecting your information from other board members if that's something that you're concerned about.
Exactly. Exactly. Which is why the third party portal is such an attractive option. What if a position's vacant when you file? There's a board position that's vacant when you file, then you just, if you have a 5-member board, one position's vacant, you're only submitting 4 board members' information. There's nobody else to provide information on. We don't have to identify positions vacant or anything like that. So now another question. So this law requires that you have a driver's license or passport if you're a board member. It does, you could have a state ID as well. That's another option.
FinCEN will also provide a private identifier. If you don't have any of those things, you can go on to FinCEN. They'll provide you with a unique identifying number that you can use to file.
Mhm. Is this applicable for LLCs as well? Yes. LLCs are corporations, stands for limited liability corporation. So you are incorporated with the Secretary of State if you don't have 20 or more full-time employees and also bring in over $5 million a year in gross receipts. You are a reporting company. You are required to file a beneficial ownership report.
Nick, there's a question. What does the federal government intend to do with the information that's submitted to them?
So the federal government, it's fairly limited on who they can give it to. I believe it's mostly banks that they can provide the information to, and then also a court if a court's pursuing you. But it's extremely limited as to where it can go. I don't even think that the IRS, I saw a question about can they give it to the IRS? I don't even think that's one of the options to provide it to the IRS. So it is extremely limited as to where they can take that information and provide it. Seeing a lot of repeat questions in here. Why do they need this personal information from somebody who missed the first half? It's a law designed to prevent money laundering and supporting terrorist organizations. A lot of, it's geared again towards small corporations because small corporations is what they're finding is where, we're setting up these small corporations that don't exist to do anything other than funnel money through from one to the next to hide the taxable income and things like that.
Someone asked for me to identify myself. My name is Lisa Allen. I do work for CEDAR, and I'm the director of accounting.
All right, budgets for 2025 are in progress. Will the CTA require a budget line? Not to file the report itself, if you are planning to use a third party to do so, yeah, you should build that into your budget. the same time, they're extremely economical costs. Good thing is you're going to have to file before 2025, so you will know what that third party is going to charge you to do it already before you actually get into 2025 in the event that you need to amend that budget or something like that.
Another question. This sounds like all small companies are impacted by this. Is this true or am I misunderstanding? I think
I'm
that is
sorry,
true.
what's that?
They want to know if all small companies are going to be impacted by this, not just community associations.
Yeah, absolutely. If you're a corporation, and if you're incorporated, you have less than 20 full-time employees, and or unless you have over 20 full-time employees and also bring in over $5 million a year, you're not excluded. You do have to comply. It's not just a community association thing.
I do have one board member making a comment. It says, I think that you will have a lot of board members who resign, and so Cedar may lose business. Cedar is hired by the association. Um, the board could fire us, that's true, but it doesn't help them comply or not comply. Firing Cedar does not mean you no longer need to comply. This is a federal law. So being with Cedar, being not with Cedar, it doesn't matter. You could be a self-managed association. You're still going to need to comply with this law. And if your board members do resign and you don't have any board members in place, that brings on a whole new set of problems for your association. So it's not something that we recommend. We do want you to remember that the federal government has this information already. You're not giving them anything they don't already have. So it's unfortunate that this is happening. It's not something I myself am happy about, or anyone at Cedar Management is overly happy about. I think if you talk to people who work with the Community Association Institute, CAI, and you talk to people who work in the community management realm, very few people think that this should apply to community associations. But our opinion doesn't matter. We have to comply with the law as it exists. And it's unfortunate, but we're here to educate you and let you know. And hopefully you will hear what we're saying and comply.
Totally agree. If you're not incorporated, I see a question, what if you're not incorporated? If you're not incorporated, you don't need to comply. If the federal government already has the information, then what's the issue with submitting? So if the federal government has the information, if you're saying what's the issue, do board members have an issue with providing that information? I don't, I can't speak, personally to them. I think it's just, giving that personal identifiable information to somebody else, maybe their issue. Or, why do we have to give it to them then so that they know, who actually is operating this corporation so that they can say, okay, these are, 5 human beings that are, citizens of the United States. It's not some corporation where there's nobody behind the wheel other than, one person who's running some type of massive fraud campaign.
Here's a good question, Nick. It says, I'm concerned that if we file, but other board members do not update their information as required, will I be held accountable for their lack of compliance?
I'm sorry, say that again?
Board member wants to know if another board member doesn't comply, they don't provide updated information. Is the board member that is in compliance going to be held accountable for the board member who's not in compliance?
Potentially, probably not. I can't see them pursuing one board member, a board member who did provide their information, who was trying to comply. If they pursue the individual, if they pursue the association and not the individual, typically we'll be talking about a situation where the association can probably pursue that one board member who's not complying, for a breach of their duty to the corporation to make the association whole, and to make any other board members whole, really.
Now, I have heard some association attorneys talk about the possibility that board members can remove a non-compliant board member. Most every association has a procedure in place to remove board members who are not meeting their responsibilities. And because this is a corporate law and because not complying could open up board members and the association to significant penalties, that would be, in most people's opinion, grounds to remove a board member that does not want to comply. to protect the association and to protect the other board members.
Yes.
But that's something that if you get in a situation like that, I would encourage you to talk to your association's attorney.
Yep, absolutely. And a good, Dennis makes a good point here. When you're passing a rule about, board member compliance, can you add the requirement about updating the information as the facts change as well? Absolutely, that would be part of a comprehensive rule. That's a great point. We're going to want to include those updates in the rule as well. Provide us all the information we need to comply, including the updates.
As I said, there'll be a lot more information to come from Cedar Management about how to comply and where to submit your information. That's not something we have in place today. We are very close to having that in place, but we're intentionally waiting until closer to the fourth quarter because we have been hoping that this would go away. So we had been delaying a little bit, but also we want to protect you and not have to have you spend money twice to resubmit in case there's any changes. So we really are looking toward the end of the third quarter, early fourth quarter before we ask you to get involved in this. If you want to go ahead without us, that is fine. But if you have to do it again later, that would be, that would be up to you. Nick, do you see any other questions that we haven't answered?
Is there an annual filing even if nothing changes? Yes, there is that annual filing that you're going to have to make, even if the entire board gets reelected. I'd say probably wait till the end of the year to make sure that nobody resigns or anything like that. But yes, we are going to have to still make that annual filing.
There's a question in here about owners and investors and realtors that own property in the association. Do they also have to file? If they own more than 25%, I believe is the answer.
Yeah, but keep in mind that's owned 25% more of the corporation, not just 25% of the units or something like that. So it depends on how your corporation is structured. Is there, for a lot of nonprofits, there is no owner, you just have members. And so if that's the case in your particular state, and we're not, for-profits have shareholders that do own portions of the company. Most nonprofits are set up so they have quote unquote members instead of shareholders. And so they're, they will not, meet that threshold. Do we have to pay a filing fee? No filing fee. There's no fee to actually file it with FinCEN. Only if you're using a third party, you would pay the third party to handle all that information and file it for you. Most of what you're paying them is for their capabilities of keeping your information protected. All right, Lisa, well, I think we answered mostly all the questions here.
Absolutely. As I said, there's going to be a lot more to come. If you have specific questions about your association or you think your association might be exempt, feel free to reach out to your association's attorney to make sure that what you're thinking is right, what you're reading is right. Feel free to ask your community manager as well. And like I said, a lot more to be coming from Cedar Management Group about our third-party option to help you file. We will be back in touch with you probably in the next month or two with more information on that. But I want to thank Nick very much for coming in tonight and helping us out and letting everybody know about the Corporate Transparency Act. And we hope that everyone has a really, really nice evening. Thank you so much for joining us tonight.
Thanks for tuning in, everybody, and thank you, Lisa.
Have a nice evening, everyone.